regarding that family pension matter, your lordship has been pleased to remand the matter, but the last line of your lordship's order, my lord, in place of disposed of, by I think by anything, kindly see, disposed of, it has been dismissed.
What difference does it make? It has been remanded. The writ has been dismissed. No problem. Let it be. The court will consider, the tribunal will consider.
Then, my lord, I'll put it. Otherwise, I'll again come.
Review of this bench. Give it.
Well,
Include it in the review we can take. Next week. Next week in it.
I'm mentioning urgent matter pending before the learned Central Administrative Tribunal. In this, my lord, there was an order directing to give compassionate appointment with effect from 2002 to 2002 and 3 year, my lord. In this matter, in the last date when the matter was moved, contempt matter has been taken up. The learned court has directed us to give appointment subject to the
Very good direction.
Appointment. This is not a case of release of funds. That could have been a different case. The matter is fixed on 12th. Kindly take care of.
It's on the list.
Yes, 95. Today is 90.
95 today's list.
Take it up day after. On 11th, it will be upgraded.
Great.
11th upgrade. Please inform.
Yes.
Have you served?
Sir, yes, sir, yes.
Yes, I'll be informed.
11th. If you can get hold of the learned advocate who is to appear, then you let him know.
Yes.
Because two wives are quarreling regarding the family pension. That has already been settled and that document has already. And before the coordinate page, that was directed to be heard. There are some change of determination, the matter.
Wait for some time, yes.
May I mention for hearing, my lord, for inclusion, my lord.
Inclusion next monthly list.
My lord, despite direction, no, next month. Hearing.
Pay attention what is going. Inclusion next month. Monthly list.
Lordship, may I be permitted to mention one matter, Lordship? This is item number 313 in the monthly list, but it is under the heading hearing. It will come under the heading application, Lordship.
Which is the can pending?
The can is pending for interim payment of some arreared family pension and
Which can? Can number?
can one, Lordship.
Don't have a separate day for application. All right, you give the slip.
Grateful, Lordship.
For operation item number 242, it will start with the matter of service matter. It will start in the year of 2012. And this is 2012. Happy New Year. Everything has already been sent.
2012 matter does not make it urgent. What is the urgency?
And they are not
Nothing is going to happen. Yes.
then matter time will freeze the matter.
Why?
So that I can take my lap to another place.
Sorry. No. Call the list. Yes, give the inclusion next monthly list. Huh? What is the interim order that you prayed for? Sorry. You join, then you mention. Take it back. Give it back. After you join, you mention. Call the next. Call the list.
Item number 1.
What is this, sir? We can't wait for you all day. Yes, call the list. What is fixed only? We don't understand what you are saying, sir. Let it be called.
But I am for the petition. I am challenged the order passed by the learned Central Administrative Tribunal have come before your lordship.
Yes, tell us what is the issue.
This is the affidavit of service. Says this is second time. I will xerox for you. Fact is this: the Railway Board lordship issued a circular naming scheme that is largest scheme.
A scheme for?
That is largest, in short, liberalized active recruitment scheme for guaranteed employment for safety staff. My lord, the petitioner number 1, being the employee of the railway, my lord, working as keyman, availing the said facility, made application.
Working as E-man, keyman.
And made application with a request for his voluntary retirement and the employment of his son was compassionate ground. My lord, made application on 2nd February 2011, and the cutoff date was 26th thereafter. The said application was forwarded to the higher authority by peon book of the concerned authority. But till, my lord, before filing the application for consideration of the application, the petitioner moved the learned Central Administrative Tribunal. A bunch of matter was, my lord, heard analogously and passed usual order for consideration of the prayer of the applicant. But they have, they have taken reason for, my lord, cancellation of the or rejection of the application of the applicant, that the age of the petitioner was not matched, only on the ground. Issuing the said impugn order, the applicant again moved the learned tribunal, and learned tribunal was pleased to direct the railway authority to examine whether the petitioner made application within cut-off date or not. But unfortunately, they did not follow the order of the learned tribunal. Again rejected the prayer. Second ground they have taken, that the cut-off date, that is 1/7/13, the petitioner did not make any application, but document shows that the petitioner made application on 2nd February 2011, that is much prior to the cutoff date. Again, on a compelling circumstances, the applicant moved the learned tribunal. The learned tribunal, now in the meantime, what happened, Lordship? The railway board withdraw the said scheme on 27th October 2017. And when the matter came up for hearing before the learned tribunal, the tribunal said that as the
First, tell us what is the scheme. You are arguing as if we know the scheme. What is the scheme?
scheme means, Lordship, the voluntary retirement.
What is the scheme? We are not asking the name of the scheme. What is the scheme? What is the provision?
If the employee retired voluntarily, then on compassionate ground, one member of the family of the employee will be absorbed. That is the scheme. In the during this time, so many candidates.
So the employees' dependents will inherit the job.
That is their scheme, Lordship.
So where is the scheme? Let us see. And how such a scheme can withstand the test of Article 14 and 16 of the Constitution of India?
That is, Malad, I do not know. But
that is what you have to tell us. What do you mean not know?
No, that is their scheme.
That is their scheme. It is not binding on us. Therefore, we are asking you. How will it withstand the test of Article 14 and 16 of the Constitution of India? People will start inheriting jobs. Then where is the question of Article 14 and 16? What will happen?
When the scheme was framed by,
so we have to enforce it.
Enforce it.
Wonderful submission you are making. You are making a wonderful submission.
No,
we are asking you whether the scheme itself is sustainable. Unless you satisfy, where is the question of enforcing it? You may come out with any scheme. Once we find or we have a prima facie opinion that it appears to be violative of Article 14, 16, you have to tell us it is not. Why it is not?
This is the scheme framed by the.
This is, you are saying for the fourth time. This is the scheme. This is the scheme. If there is a scheme, now let us see if there is a scheme that if you wear a particular color of clothes, you will get the appointment. Should we enforce such a scheme?
But 2017, they have, my lord, applied the said scheme.
That helps you in sustaining the constitutionality of the scheme. We are asking you a simple question. You are seeking enforcement of a scheme which prima facie, from what you say, we doubt that it can withstand the test of Article 14 and 16. Tell us that it is constitutional. The scheme is constitutional. How it is? Show us where is the scheme.
Some number of cases.
Yes.
Again, my lord, only my lord, give some time so that I can produce before lordship the scheme.
No.
It was not, my lord, supplied to the employees. But the note,
You have applied under the scheme. A scheme was not supplied. You don't make just any submission. You are claiming benefit of the scheme. You can't say you don't know the scheme.
my lord, 1 or 2 day time may be granted.
Yes. From the submissions.
Item number 2. Item number 2, I am appearing for the petitioner, my lord. I am led by Mr. Jivendra and there are two identical. My lord, right, my lord.
No, your interim order prayer has already been rejected. There is an order rejecting your prayer for interim order. So you argue the matter.
There are two identical matters. My lord. One is
Argue this case. We'll see when that comes. Can you use the mic, please?
kindly give me some time, my lord. Because
You are saying urgent interim order, time, everything in the same breath.
can copy, my lord. Can copy.
Huh? Just now you said urgent, contempt, interim order, and now you want time.
Can copy with not with.
Huh?
Can copy with not with us, my lord.
Which can?
Can 1 and can 2 of 2025, my lord.
Can 1 and can 2. What is can 1 for?
An application for stay of execution order dated 15/1/2025 passed by the Honorable Tribunal MA number such and such.
Have you filed the can? It is not
Yes,
here.
my lord. Yes, my lord. Can 1 and 2, my lord. And my lord, this is affirmed on 22nd February 2025, my lord.
Not today.
Yes, my lord.
Yes, not today.
Item number 3.
Oh, sorry. I am the petitioner, my lord.
Let us see. Let them make out a case, then we'll call upon you.
Lordship, there pursuant to a notification of the RRC, the Regional Recruitment Railway Recruitment Committee, Recruitment Cell, Lord, I applied for a post of Group D, I being an OBC candidate, but it was rejected. I was not allowed to.
You applied for a Group D post
Group D.
pursuant to an advertisement.
Yes,
When advertisement was issued?
Lordship, kindly come to. And not me. Notification date 0116 of 2006.
2006.
6.
0.
0116 para 2 million. Para 2 of my application. I applied for the group D post. I appeared in the written examination, physical efficiency rate, medical examination. I was declared medically fit by the competent authority, medical officer. Briefer nahi. What a language.
What is the, where is your OA?
Milord, may I be permitted to submit one thing, Milord?
Where is the OA? What submit?
Wait, where is this? Page 45, Milord. Annexure P9. Wave 350 by 388 by 2018. Milord, may I be permitted to submit one thing, Milord, before your Lordship submit. Kind pleasure, Milord.
What is the prayer in OA? Where is the prayer?
Okay. Now, last. Page 62, Milord.
Yes.
The matter was taken up last on 15/5/2024 by the Honorable Justice, by the Division Bench, decided by Mr. Toboboto Chakraborty. The order was passed, my lord. The order was passed by the Honorable Justice Chakraborty.
We have the order, don't worry.
Huh? No, yeah. Yes, this order was passed.
We have the order, yes.
Okay. Then, my lord, it was communicated to me on 5th July 2024. This is the communication, my lord, by the railway authorities. I'm handing up the call.
The order.
Send by post also.
Go ahead and take. Yes, why are you showing this? This is not part of the record in the tribunal.
Now, pursuant to this notification, later I have communicated, I have made this representation.
But this is not in part of the record. This is something
After the order passed by my.
the merits of the order. What is wrong with the order? Tell us. You want to pursue that, then we will allow you to pursue that.
Yes.
But you must address us on this merit of this case.
Mismatch. According to that, according to the authorities, the representation was mismatched with the signature also. But I have made the authority. I have made it appeared in the written.
No, you have not.
Huh?
You have not.
I have did that.
No, you have not.
According to them.
They issued a show cause. They gave you a date. You did not go.
Now, the show cause notice was received by me on the date of specification of.
Whatever it is, you did not go. Where is your reply to the opposition filed?
Communication on the date of.
Where is your rejoinder to the reply filed in the tribunal?
Yes.
In the tribunal, the railway filed a rejoinder.
Yes.
A reply. Where is your rejoinder? You did not file a rejoinder.
Kindly give me a time. I have to file the rejoinder.
You did not file a rejoinder.
My humble submission. I have the instruction that I file the rejoinder. Also, kindly give me some time. I shall file the copy of.
Bring it tomorrow. Third line counsel for the petitioner.
Kindly see the page number 92.
What is it?
This is the rejoinder. Rejoinder on behalf of this.
You don't even read the brief before coming to court. Very wonderful way of assisting them. No, let us see. You don't even know what is there in your brief. And you are here to assist the court. Whether you are giving service to your client or what you are doing, we don't know.
Then Miller, can you come to day after tomorrow? I shall
No, no, now it is here. There is nothing. I wanted to see whether they have made any reply to R9. This page.
And 92. paragraph.
Here, the brief. Series reply. Page 96. Paragraph 7. Yes, you have not denied.
Pardon, my
Nothing can be done for you, sir. The panel lapsed in 2014.
lordship.
16.
16.
2014.
Page 97. Hmm?
15, 12, 16. Your claim was rejected. 15, 12, 16. When did you challenge the order of 15, 12, 16? No.
PC candidate will not kindly consider this. And this is your lordship.
Panel lapsed on 10th August 2014. Can be done. So what is your submission? Tell us.
I beseech your lordship. As a OBC candidate, literate one, this is my
Yes, take down. Heard learned counsel for the petitioner.
Yeah, related not.
Item number 4.
Okay.
List on
Item number 5.
I beg to appear for the petitioner. May I? This is the case, my lord, where the petitioner before lordship acquired higher qualifications.
sorry,
Acquired higher qualifications. After joining service, he acquired higher qualification.
service of
A technical staff. He is
in the railways.
no. He is Ministry of
Department of Electronics.
Electronics.
So the basis of his entry was all right.
All right.
Later on, he acquired higher qualification.
Higher qualification.
So there's not an issue relating to recruitment.
No.
Then
Then, my lord, there was a scheme. Following 1983, certain qualifications are given for higher post in 1993, 83.
93.
83.
And when did you join?
I joined later on.
You joined later.
Now, no, that scheme, during service, I acquired qualification. During my service, I acquired qualification. The scheme says
The scheme is of 83.
83.
So its scheme is prior to your recruitment.
Yes.
All right. When were you recruited? When were you appointed?
Sorry, December 88.
Appointed as what?
And he was initially appointed
Laboratory
yes, as laboratory assistant A.
Lab assistant.
Lab assistant A.
Are you seeking benefit of the 83 scheme?
83 scheme read with 84 scheme.
given, already given.
No, given, but prospective date. That is the case.
So the fact that you possess the requisite qualification for grant of benefit under the scheme is not in dispute.
No.
Only the date from which it is to be given,
Yes.
that is the issue.
Whether from the date of eligibility or from prospective date. That is the issue.
So let us see the scheme. What does the scheme say?
Scheme is silent.
No.
Lordship, kindly come to page. Just no. Page 35 for a moment.
35.
35. Paragraph 5. Promotions and normal annual increments.
Five is relevant.
Yes.
5 is relevant.
Yes, 5 is relevant. Now, pursuant to that paragraph 5, my lord, Lordship, kindly come to page 65. 62 for a moment.
You know how 5 is relevant. 5 is talking about promotion and normal annual increment.
Increments and the qualifications are mentioned.
Where is that?
Page 37 onwards, my lord. Now, pursuant to that paragraph, my lord, a scheme was framed. Page 62.
Pursuant to which paragraph?
Paragraph. Lordship, kindly come to page 62. Lordship, kindly come. Page 62.
No, 84. That is the 84 scheme.
Yes.
So that has to be read with 83. But
Yes.
what does 83 say? We are
No,
not-
83 does not say about, my lord,
any promotion on the basis
according
of a higher
qualification.
qualification.
Yes.
So that has come for the first time in the 84 scheme.
84.
At page
Page 62. Relevant page is page 63. Paragraph 3.
It is inquiry.
you were recruited as a lab assistant.
Yes.
Suddenly list as and show me where the message.
They have granted me subsequent under that scheme.
It's a BTEC.
When did you acquire the qualification?
Yes. Lordship, kindly come to page 17.
Page
17 of the writ petition. Paragraph C.
70.
Page 17, 17. Paragraph C.
So 91, 2003, 7 and 10. These are the 4 years in which you say you have acquired these 4 qualifications. Now,
That is not in dispute.
and all on the basis of the qualification acquired in 91 also you were entitled to
Yes.
some promotion.
Yes. Yes.
That was to the technical assistant B.
B.
So when did they give you that?
No, they gave me everything in 2016.
2016.
That is,
All at once.
yes. Now, Lordship, kindly come to, due to denial, I filed on original application.
Hmm?
Original application I filed. That is at page, my lord, 100.
For
Due to denial of that benefits of that scheme. Page 100. This is my first case. This is in the year 2009. That was disposed of on 9/8/2011. Penultimate paragraph is 101.
yes.
Now, my lord, during pendency of this original application, Lordship may kindly come to
This
page
is of 2011.
date 2009 OA, 2011 it was disposed of. Lordship kindly come to page 86. During pendency of the original application,
Yes, what happened?
they said that page 86, my lord. I am directed to refer to your such to forward herewith the necessary documents confirming approval/recognition of the course institution in respect of the following 3 employees of this laboratory who are found suitable for special review. The third name is mine. During pendency of the way, this letter was issued. I was one of them who was found suitable for special review. They recognized my qualifications.
No, but this is prior to this order passed by the
Yes,
tribunal.
yes, prior to that order. During pendency. Now, Lordship kindly come to next page 84. This is regarding review promotion in respect of below group A officials.
Page 84.
84.
No, all this is immaterial now. Whatever it has to be, it is an order passed on your OA 808.
No,
Till that day, they did not consider you
no.
for grant of this benefit. That is an admitted position. Prior to that, in 2008, they have already rejected your claim. That you have never challenged. And by the time the order was issued by the tribunal said you may be considered as per law.
No, then my lord.
Therefore, there is nothing that can that can be now claimed prior to issuance
No,
of the tribunal.
thereafter none of that case.
Yes.
Thereafter another case. Now, Lordship, kindly come to page 87. Is 2012. Decided on 3rd March 2014.
Oh, so paragraph 3 has allowed you to agitate the claim now.
Yes. From the date of eligibility. Now, what happened thereafter? They did not comply with this order. They challenged this order before this Honorable High Court.
Then what happened?
There they withdrew. Now, Lordship, I may kindly come to page 98. Sorry. Page 89, sorry, 89. This was handed over to me during in course of hearing of contempt application I filed.
So, all right, where is the order passed thereafter?
Thereafter, my lord, contempt was dropped on the basis of that assurance.
So now they said we will consider, then they must have passed some order.
Yes.
Where is the order? Let us see the order.
Page 92.
Page
92. That is one a challenge in this.
Obviously, that is
Yes,
why we
madam.
want to see.
Yes. Yes, yes. This was under challenge. Prospective rating under challenge. With effect on 23rd March 2016. Earlier order was challenged and withdrawn.
This 1st March 2016 order has been challenged.
1st April.
1st April 2006. In the present way.
Yes. That it should be retrospective from the date of my eligibility as per order of the London Tribunal.
No. Tribunal has not said to give it from the date of Tribunal has, please read such direction.
Lordship, kindly come to
Please read such direction.
88.
Yes, you read the direction.
Yes. As the respondents themselves desirous of considering the case of the applicant in terms of policy 83, operating as on this date, let the case of the applicant be considered appropriately in terms of the said
So
policy.
therefore that means give. Consider means give.
No,
Then
with effect from the date he became eligible.
So you consider with effect from that date means give. There is a direction to give. What is this?
No.
There is no direction that you must be getting it from that date.
But
you may be considered.
But
Consideration does not mean that there is a direction to
benefits with effect from that date.
No, they have considered. You are saying there is a direction. There is no direction.
No, Lordship, it means they must. They have not said that.
And we have to learn something new today.
No. I am sorry, my lord. I cannot.
How can we?
No, my lord.
It says to consider whether he will get from a retrospective date. That means
That
he
they have
must
not
be
done.
given. So that does not mean he has to be given. You said there is a direction. There is no such direction.
Let them show that they considered us, and then
this is the order which has been passed.
Yes.
Now you are before the court. What is the lacking in consideration? Show us.
They have not considered for retrospective date at all.
Under which provision? They have to give from a retrospective date. What has been omitted? Show us.
Because 60.
Where in the 83 or 84 scheme says to give with retrospective effect? Show us. Then we'll see whether it has been omitted or not.
My lord, I was considered in 2010.
Well, may I say something?
Once you
Special
have
review.
See, before 2008, you can get nothing. In 2008, there is a rejection which you have never challenged.
That was, I think, a challenge.
There is a rejection of your claim in 2008, which you have never challenged.
I challenged.
So the policy is very clear, my lord.
No, I challenged.
On 7/1/2008, come to page 100 of your brief.
Yes.
Paragraph 2, last sentence. There is no question of traveling beyond this. That order has never been challenged. After that, you have moved the tribunal twice. You have chosen not to assail this order. So how you can get anything prior to 2008, prior to that
No,
rejection?
but to the 2008, I'm not asking.
So
I'm asking 2010, they considered me special review. They found me suitable.
in 2010.
Yes.
All right. Where is that? Where have they found you suitable in 2000?
Yes.
And where is it that it is to be granted from a particular date?
On acquiring, today I am acquiring qualification. Well,
See, you are asking from the date of acquisition of qualification.
yes.
We are asking you to show the basis of such claim.
Lordship, kindly.
Where is the mandate that it has to be considered and granted?
So today I am acquiring a qualification. The page 62 is the scheme.
See, you cannot get anything beyond the scheme under which you are claiming the
Yes.
benefit. We are asking you where in the 83 or 84 scheme there is a provision that the date on which you acquire the qualification, you are to be given the promotional benefit
Lordship,
with
kindly come to
effect from that date.
page 62. Once. Today I am acquiring qualification. Well, they cannot, after 10 years, if they give.
Pilot.
You are shying away from the scheme.
No
We
scheme.
have been
Lordship,
asking you from
page
the very
62.
beginning. Page 62, you want us to read 10 pages of the scheme.
No, page.
We are asking you where is that provision
Paragraph 3.
upon which you are relying.
Paragraph 3.
Kindly see 3B. 3B.
3B and 3E.
It says,
There is a standardized
Yes,
date
my
for
lord.
review.
and also, my lord,
How you are making a claim
also page 65G.
contrary to the scheme, we don't know.
Where G says it can be considered only once G, my lord. Kindly see page 65.
Come to B,
Yes, my
we
lord.
have marked B, we have marked C, we have marked E. Contrary to these provisions, you say the day I have acquired the qualification, give me the
No,
promotion.
Lordship, kindly see E.
Yes, read E.
On acquiring additional, the concerned employee will be considered for special review
Considered for.
on the standard date
Standardized date of review
review
for
for
that
that
date.
immediate.
So when is that
immediately
date?
Following the
When is that date?
they can say, my lord.
Oh, they can.
have not,
They have to make out your case.
No, they have not stated anything in
They have to make. Where have you said that the standardized date occurred on such and such date? There was a vacancy existing in the promotional post.
No, the vacancy, it is not vacancy based.
Oh, it is.
No.
It is.
No, my lord, it is not vacancy based. It is
It is, sir.
flexible scheme. No, this is not vacancy based.
It is a personal promotion
Not vacancy based.
based on your qualification.
Yes, not
But
vacancy.
it is linked to vacancy also.
No, my lord, it is not linked to vacancy. Lordship, kindly come to page 84 for a moment. They considered me by special review. Special review, they have considered me in 2010. Found suitable.
Where is your name?
My name is 6.
So where is the special review? You have been found suitable for the review. Where is the review proceedings?
This review proceeding is not with me. Review proceeding is not with me. This is confidential, my lord. Second one has got.
This is, see, this they have forwarded. Much is to be done after this.
Let them produce the records.
It is apparent from the next page. You want to make out your case from their records. We will not permit that. You have to make out your own case. Then we can ask them to answer.
Yes, that has been done. Page 86.
So all this you are not showing. Let them produce the
No,
record.
page 86, I've shown, my lord. Initially, I've shown. Qualification was recognized and approved.
Yes. So this is another step.
Yes.
In
That is the last step.
2010.
That is
In
the last step.
2010.
That
Yes.
is the last step. That is the final step.
Where was that letter by which you were granted the benefit? Where is that letter? The benefit has been granted by which communication?
96, page 96 most.
Page?
Page 92.
92.
Yes. That is the almost after 6 years.
So now just show us where is the provision either in 83 or 84 scheme that the date of acquiring qualification is the date on which you have to be given the promotion.
It says immediately after acquiring qualification, they will consider. See, she says. I've shown.
So there is no basis to claim from the date of qualification.
Immediately after.
So there is no basis for
And they have
claiming.
done it.
So there is no basis for claiming on the basis of the date of qualification.
I cannot argue with your lordship.
Then
This language is very specific, my lord.
yes.
B. Employee eligible for, while the acquisition of an additional qualification will make an employee eligible for consideration.
Where are you?
B, my lord, 64, page 64, B. While the acquisition of an additional qualification will make
And
an
lordship-
employee eligible for consideration
Now, lordship,
for the appropriate post, it will not ipso facto make him eligible to be placed in
But
higher.
what took you so many years to consider?
Well, possibly no, as for from previous orders, I said possibly no special review meeting was held.
That is no answer. If you come out with a scheme, why should you not hold a special review?
Well, there,
When you come out with a scheme, you say this is how it is to be done. Immediately thereafter, there is supposed to be a standardized date of review. What have you done? After issuing a scheme, can you make it arbitrary and at the whims of the authority to do it as and when they want?
this was
Are you
possibly
promoting acquisition of higher skill and qualification into the organization or you are defeating it.
But this was possibly due to change in the structure of the ministry, my lord.
We don't know.
No, but
It is a possibility, but
No, I had read somewhere, my lord, but
you have filed a reply before the tribunal.
my lord, reply says, my lord, these rules were not for the for this cadre, my lord, possibly.
He was
Then
giving.
how have you given it to him?
Subsequently under contempt, my lord. That is the explanation.
No, no,
That is what they have said.
Yes, my lord, in the reply, my lord.
no, they withdrew the writ petition
Yes, yes.
filed before this honorable court.
Rejoinder to আপনার হবে না?
Another thing can I show, my lord? Lordship, kindly come to page 84 once.
Just wait.
Kindly take up from paragraph 108, my lord. 108. This is our reply, my lord.
108.
Page.
Here, my lord, the history has been laid down, my lord.
Page 108.
Page 108. Page 108. My lord, this is page 5 of our reply.
Yes.
রিসেন্টলিটা কি হয়? রিসেন্টলিটা কি? Paragraph 14, my lord, possibly DOPT did not formulate a special similar policy was not notified for this.
No, but he is in group A.
He below group A. He was below group A.
Below group.
No, he said he was recruited as lab assistant A.
Level below
That
group
is-
A. মানে
That is
Group A,
below group A, my lord.
group A is class 1. This scheme is for below group A.
From group A.
So this lab assistant A is a nomenclature of the post.
Yes.
It is not the group. Group is B.
No, see.
C.
Seventeen, it says, "But in absence of policy for below group A level, special reviews were not conducted."
So 83 was for below group.
Subsequently, it was clarified and then it was conducted.
83 was for below group A.
Yes.
Then after the 5th PRC recommendations, it was what happened?
It is below group A. Still.
No, change টা কি হলো?
Change
What
it.
change?
It was for group A.
Personnel notified a revised flexible complementing scheme
For group A.
That is another.
So that is above him.
That is above.
This superseded the earlier policy. So 83 policy was superseded.
No, my lord, possibly not.
No, because
This is why I was not relying on this from beginning.
So where is this 9/11/98 document that will reveal whether it is whatever is being stated is correct or not? The scheme is an office memorandum issued on 9/11/98. Where is that? It must be part of the reply.
They subsequently said no, scheme was not changed.
No, it was for possibly there is somewhere a recording also.
No, please, again, please see
No,
paragraph 13.
They said that there was no such scheme.
No, it is mentioned. OM number.
Subsequently, in contempt proceeding, they said no, there is no scheme.
Whether there is an OM 9/11/98, where is that?
That must be there, mother.
They are giving the details of the with number, date, and everything. It must be there. It must be part of the reply. It's not a vague assertion that there is a scheme. They are giving the details of the scheme.
It is there as page 28, but does not mention any date or.
It has not been marked as an annexure. It has just been mentioned. A revised flexible complementing scheme was introduced for Group A, and they say that the earlier policy was superseded.
That is Group A, my lord. It is below Group A. My
That-
scheme is below Group A.
Below Group A in 83, after 5th PRC, for Group A it was introduced and the earlier policy superseded.
Regarding Group A.
No.
Earlier policy regarding Group A, my lord. Group A onwards.
This is possibly the contradiction because this.
What they are trying to say is that after 9/11/98, the earlier policy was superseded.
83
But that-
also, my lord, 83 also was some benefits were being given to the Group A. So it was considered whether similar benefits will be given to the group below Group B. That is why the policy was formulated.
Actually, we are not able to see the scheme at all. Annexure 2, where is Annexure 2 of the scheme?
I don't know.
Well, can you see page 35? This is where, because reference the Group A, the scheme personnel policy for Group A scientific and technical officers out and they would also apply to mutandis in scientific technical officers below Group A. So, Mala, the scheme for Group A was possibly made applicable to below Group A officers.
That's why they are saying in 98 it was superseded.
Yes, Mala. So Group
So
A.
where is that 9/11/98 document? That's why we are asking you. In paragraph 13, they have said that it was superseded.
Whatever বলেছেন না হতে পারে ওই পার্টটা superseded.
And 6.1 is the relevant clause of this 83 scheme.
This document, my lord, does not possibly.
Plus, somewhere we have I had seen that it was also linked to availability of vacancies.
That is regular promotion, my lord. That is regular promotion.
This is a personal promotion.
Yes, it is
Only
flexible complementing scheme. My lord, like upgradation.
not dependent upon existence of a post.
Possibly not, my lord.
But this order that you have challenged is granting you only one benefit.
It's all benefits together, my lord. Up to.
No, it is granting you just one benefit.
He is being granted the highest benefit. Because, my lord, the clause G says only one special, you can take benefit of the special review only once. G, your lord, you can see page 65, G. This thing will be taken up once.
Now, if your lordship
So,
pardon me,
their prayer, my lord, that every time I have acquired, I will get, see their prayer. Their prayer is that every time I have acquired.
no, I say that this benefit should be from
Time to time, thrice.
they
Relief
have-
is an order directing
Now,
the
lordship-
respondent to
lordship,
amend the impugned order dated 1
May I submit
by
one thing,
granting
my lordship?
promotion to application under special review scientist B with effect from January 2008.
Yes, we have seen that. We have seen.
So he is actually claiming 3 promotions.
But G limits your benefit to once.
All right, my lord, but date of effect. Lordship, kindly come to
So the benefit which has been granted, when did you acquire that qualification?
that in 2008.
January 2008.
Yes, 2008, page 17.
Page
17, my lord.
That is.
In there 2007, sorry, 2007, I acquired.
2007.
Yes.
No,
MTech, not MTech, my lord. Earlier, 2007.
based on your BTech.
BTech, yes.
Based on your BTech. So 2007. And it has been granted with effect from
March 2016. Now, may I show you, Lordship, one document, my lord, two documents. Page 84, Lordship. I was considered along with serial number 2 C. Vishwanath B. Lordship, got it. Page 84. Second name, Sri Vishwanath B. I was considered. Now, this Vishwanath B has been given with effect from 19/5/2010.
he is not in your category. He is a scientific assistant group
No.
A.
No, he was considered, he has been given.
We don't know what is the policy for. How can you compare apples with
Same
oranges?
policy. Below group A. Lordship, kindly see, officer staff below group A.
You are a tradesman, group F.
No,
What no?
I am, well, a tradesman F.
Yes, and he is a scientific assistant A, and you are comparing with him.
No, comparing because all are
Can you?
officer staff below group A.
Maybe, but we don't. There is no. You cannot compare with him.
Now, Lordship, kindly see.
And his qualification is BE Electronics and Communication. You are having a BTech Computer Science.
Same thing, when a BTech, my lord.
Yes.
Bachelor degree. Now, he filed a case. He has been granted, my lord. I placed before the learned tribunal, page 188. 188. Page 188. I placed before the learned tribunal. Learned tribunal did not consider at all. Page 1.
No, how can you cannot compare with him?
No,
that you
learned
cannot.
tribunal has to consider it.
You cannot. We are considering. We don't find that there is anything to consider. How can your
And Lordship, kindly come to page 94, 194 for a moment. Paragraph 12, last 4 lines, my lord.
194.
Right.
On impute order.
Yes. In absence of any policy guideline instruction of government regarding prospective promotion for under special review,
it must be retrospective written as prospective. It is quite an obvious mistake. And that is, we have been asking you, where is the provision that it is to be given?
My case was considered in 2010. My qualification was approved in 2010. They're sitting tight over the matter. Others have been given.
But why they have delayed? That is the issue.
Others have been given. And those who are not found suitable, their names are also.
Where is the scope for you to take up this issue as and when you like?
Possibly, no. That is why I was referring to those paragraphs. There was.
But you are referring to the paragraph without showing us the documents.
No.
Merely for your saying or your statement, it cannot be accepted.
There were possibly some ambiguity whether this scheme will be applicable for this personnel or not. That is possibly the only reason why.
That is all you have to submit. We can record that you submit that there was possibly some ambiguity. Therefore, the court should not interfere.
That is from 98 to 2010. 2010 I was considered.
This is the third time we are asking you.
Yes.
Come out clear with this.
Well, kindly allow me to take specific instruction on this because it says a bit.
Because from 2007 to 16, what is the justification for keeping him pending for 9 years? Such schemes are obviously formulated for infusing a higher level of skill. But if the scheme is not followed up by the action which is required, then why should anyone acquire a skill?
Because at one place they say the scheme was not.
After he has chased you in 2 original applications, contempt, writ petition, finally you decided that all right, I will consider it. Why after so many years? And why he should be made to suffer for your delay? You have shown us a paragraph
Yes.
that refers to a scheme. That scheme is not before us.
Can you allow me some time to take instruction on this? At least instruction on their reply, my lord. Reply is a bit vague, my lord. Reply indicates that this policy was not in vogue. But why it was not in vogue, my lord?
For a particular period.
Yes, my lord.
Thereafter, it again has become into vogue.
Yes.
But that is whatever has been stated is prior to 2007.
Prior to
98.
yes, yes, obviously. Even if 98 comes, my lord,
Therefore, we are asking you what have you stated in the reply about this delay?
there are pleadings, but I do not think those pleadings have been, my lord, paragraph, for example, my lord, in paragraph 19 and 20, after seeking, 20 says, after seeking necessary clearance from the personal division, METI, the key electronics, Ministry of Electronics. Again, this is at page 109, my lord. Again, consider under special review with approval of competent authority.
Again, my lord, earlier considered.
But the issue was taken up with nodal ministry for advice of judgment given by ওটা বলছে এই সেন্টেন্সটা কি কারেক্ট? Policy was continued on a yearly basis with approval of honorable minister.
আমরা তো 8টাইতে জানি।
So earlier promotions you have been given. Earlier promotions you have been given.
The last one, not last one.
You are since
is
then you
regular.
have been arguing that all these promotions have not been given. All those promotions have been given.
It is regular. Not under computing.
Come to page 105.
Yes, yes. I have got him other promotions, earlier promotions. That is not under scheme. I have given post-based promotion.
Yes.
Post-based promotion.
Normal.
Normal promotion. Not under the scheme. Post-based promotion.
So you are actually, your claim is only for this promotion.
Yes.
Nothing.
Special review.
You became a tradesman in 2004.
Yes.
You acquired the NCVT diploma in 2003. BTech in 2007.
Yes. And MTech in 2010. And that is not BTech is.
There is no justification given for not considering. Page 3, there is nothing. Filed an original application, you say that they filed an original application. Why it was not considered? Educational qualification is not the sole criteria. You have said that also.
Yes, my lord.
There has to be
The
special review.
explan-
There has to be special
the
review.
explanation, it appears from there is that for some reason they were under the impression that this, and they were not conducting any special review promotion. That is my lord, the sum and substance
But
of
the
it.
fact remains you have not worked on that post for so
That
many
is
years.
one.
No, it is not post-based.
No,
This is not post-based.
Just the scale has to be.
Yes.
it
flexible
is not
computing-
vacancy, but it is definitely post based.
No, not post-based. It is flexible computing scheme.
No,
Like upgrade
it
ACP
has-
and SCP. It is not post-based.
Right.
বলেছো 84 page 84 তারপরে অ্যাপ্রুভ করবে সাবজেক্ট না এই যে এটা তো বোর্ডই করেছে ডিপার্টমেন্ট এটা এই তো করেছে মিনিস্ট্রি করেছে তারপরে বলেছে সাবজেক্ট টু অ্যাপ্রুভাল অফ দ্য দ্যাট অ্যাপ্রুভাল ওয়াজ গিভেন জুনে
তাকে কি কনসিডার strong contact
Actually, we have not even read the scheme properly. Scheme is there. Scheme is there. Both scheme is there. First scheme is at page 30. The second scheme is at page 62. That is 35. Second scheme is at page 62.
The learned tribunal has taken note of a letter dated 18th May 2017, you know,
কিন্তু সে ইমপ্লিমেন্ট
page
করতে
5 of the
এত
impugned
বছর
order. Paragraph 11, my lord.
ব্যাঙ্গালোর
This is what you have stated.
Second paragraph, yes.
This is what you have
It
stated
may
in
be
your
mentioned
reply.
here that group, yes, my lord.
This is exactly what you have stated in your reply.
জাজমেন্টটা পুরো এইখানে
And this promotion order was issued in the contempt proceedings, during the contempt proceedings.
After it was dropped, it was.
No, my lord,
15 was
an
dropped.
appeal was possibly preferred, then that appeal was withdrawn.
That was against the order passed in OA, not in
OA.
contempt. But they have moved a contempt also.
Contempt
Yes, yes.
page 91 is the order, contempt order. On their assurance, Lordship, kindly come to page 89. That was. Thereafter, this order was passed.
So even after this, they have taken 2 more years.
For 2 more years. March 15.
Something has to be.
But I relied upon a decision before the London Tribunal. 165 is the relevant paragraph, page. There was the question that there is a delay in constituting the assessment board. So the Honorable High Court decided that since it was a delay on their part, it should be given from the date of eligibility. That was challenged before the Honorable Supreme Court upheld that order. 65. SK Murthy's case. See, here my lord post based. Here our case is not vacancy based, it is post based. 165 paragraph 6. Here my 2010 they've already convent and found me suitable. My designation, my qualification was approved also.
That's why we are asking. Any justification for taking 9 years? That's why we have been asking. There appears to be nothing.
They have given some justification which may not be very convincing, but let me take be specific whether there was actually something stopping them from doing it. And my lord, I will draw a difference with other judgments only because this policy specifically disbars this benefit, my lord. Because of clause B, no other policy usually does have this that while acquisition of employee will make an employee eligible for consideration, it will not ipso facto make him eligible to be placed in the higher grade.
But the same policy requires you to have a standardized review date. The policy is
confusion was, as far as I have understood, was whether at all this policy was applicable for this employees or not. Possibly this what I have been.
No, from 2007 there is no ambiguity. When he has acquired the BTech, from then onwards there is no ambiguity that he is entitled. You are just saying that we are doing it, we are doing it, we are doing it. Lingering the matter. Whatever, whether it was applicable or not in 98, that is not relevant for 2007.
Definitely.
After 2007, there is no.
Council, you intend to have specific instruction from the authority.
Yes, yes, yes. a specific reason whether it is valid, there is any other than what has been stated, other than what has been, is if there any.
Can that be taken into consideration now at this stage?
That was not before the tribunal.
But tribunal has placed reliance, my lord, on that reasoning, my lord. Tribunal has placed reliance on that reasoning.
Very well. But the parties, not the parties. On 23rd, we'll pass the order. We have fixed it on 23rd under the heading for orders, but we'll pass the order.
Keep the
Item number 6.
বাইরে আছে দেখছেন না তো? বাইরে দাঁড়িয়ে আছে, ব্রিফটা ওর কাছে মার্কিং করা আছে ওরা
Yes,
this matter is due to appear on 16th, my lord. Now, my lord, today the matter is appearing in the list.
due to appear on 16.
As my lord, we mentioned in the my lord filing column, my lord, the date was mentioned on 16th, my lord. I think, my lord, sorry.
Achha. So even though you are here, you will not argue.
No, if your lordship takes up, my lord,
No, if you don't want to, don't do it.
uh,
Why should you say such a thing? The matter is to be listed on 16th. It is here. You are here. It is your case.
other side is not here.
If your case requires, we'll call upon them to come.
Lord, kindly sees the MP in order, my lord.
The rising out of AFT.
Yes, my lord.
What is it? What is the issue?
My lord, the respondent was in service in 2001, my lord. In 2001, my lord, it was detected by the medical board of the, my lord.
This is for the Union of India. Writ petition is by Union of India. What has been done? He has been granted disability benefit.
Yes, my lord. 20%. Yes, 20% disability pension has been granted, my lord. My lord, as per my notification, my lord, if a person, my lord, after 2019, my lord, it has been detected or in service, then he is entitled to, my lord, get this benefit. But it has been tribunal held, irrespective of anything, my lord, he is entitled to get the benefit. My lord, as per circulars specifically said that before 2019, he is not entitled to get any disability benefit 20%. It was here, it has been given to him 1.5%. In 2001, he was joined in the army, my lord. In 2001, it was detected that he was suffering from light, my lord, medical problem, my lord. And my lord, accordingly, my lord, he has been given disabled pension of 1.5%. But tribunal held, my lord.
Let it come on 16th. The respondent will be required. We thought that
Seven. Seven.
Even my lord, I am for the petitioner, my lord. My lord, in this matter also.
Railway.
Railway, my lord. In this matter also, you have filed that application, fill up the A form, mentioning that matter will be appear on
16th.
15th, my lord.
15th. 15th, how it can appear? 15th is Sunday.
Then my lord, the
16th.
16th, my lord.
Same order.
Lordship. I beg to appear on behalf of the Union of India in this matter, Lordship. I'm being led by Mr. Souvik Nandi, senior advocate. Lordship, there has been a bereavement in his family. I am requesting Lordship for a week's accommodation, Lordship. There has been a bereavement in his family, Lordship.
What do you want?
Lordship, I'm praying not this week, Lordship.
Council.
Item 7. Okay. 7. Item 9. I'm grateful. Item 7.
File it.
Tapan Kumar Mukherjee is appearing in this matter for the state. He is on his leg in court number 26. I'm praying
Krishna is not here.
short pass over, Lordship.
None appears for the petitioner.
Item 10.
My lord, due to some urgent reason, my senior Mr. Ghosal is out of station today. So I am paying for not today. And kindly,
Not today.
if kindly fix this matter on tomorrow, then I will definitely.
Not
forget.
today. Call the next.
Item 11.
Your Lordship, I am appearing on behalf of the state led by Ms. Sinha, Your Lordship. She is not available in the town, Your Lordship. I am praying for not this week, Your Lordship.
Where is the petitioner? Not today. Call the next case. Call next. Not today. Oh, you are here. You are appearing in it.
Well.
Let us see tomorrow whether they.
Item 12. At 12, I appear for the petitioner.
What is your date of birth? You were born in which year?
Well, admittedly, that I was below 18 on the date of application.
When were you born? What is your date of birth? Possibly 89 or 90.
Date of birth.
(1990).
1990.
1990.
Just 2 years before his father died.
Well, the
Mother was eligible.
my mother was eligible. She applied. But for years together, her application was pending. Well, kindly have a look to the pages. My mother sought for compassionate appointment.
So an application made in the year 1993. No steps taken for 12 years. What did you do for 12, 13 years?
That's why I wanted to place the records before your lordship, starting from page 39.
What is it? Tell us first.
After the death of my father, within 6 months, my mother applied for.
We are asking you, mother made an application in 93. 93 to 2006. What was she doing?
If your lordship.
For 13 years, she had no urgency for a compassionate appointment.
May I place the records?
No, this is a hard facts. What is there to place?
Well,
For 13 years, what were you doing? Tell us. What have you said? What were you doing this period, during this period?
Let the department, the interdepartmental communications are there.
They
Annexed to
are
the petition.
asking you what you were doing for 13 years.
Well, I waited for the final communication.
For 13 years. So there was no pressing urgency.
No. Who said?
You are easily managing for 13 years.
Yes, I've understood. I've understood.
Please
What
try to understand what we are saying.
I've understood.
Had you been in penury, had you been actually in a state of affairs where it was impossible, you would not wait for 13 years.
May I now answer to the question?
Yes.
Well, if your lordship kindly turns to page 41.
What is it?
Well, it is the Superintendent of Police in the year 1993.
Yes.
5th of September 1993, writing a letter to the Deputy Inspector General of Police, Writers Building, Kolkata, for employment of my mother. Page 40.
Yes.
Then, page 41. Well, these are very important. Well, the Deputy Inspector General of Police, West Bengal, is writing back to the SP of the district on 13th of December 1993 regarding employment of my mother. Then the DIG said that her case will be considered as per her turn and suitability. Then, a lordship kindly have a look to page 42, 94. It is the letter of 17th of February 1994. This is also from the Superintendent of Police to the DIG. Same thing. Then your lordship kindly sees the type copy is page 43. Page 44. In 1997, my mother once again made a representation to the IG, North Bengal, for a job. Well, got it?
You filed a reply before the tribunal. Did they file any reply before the tribunal?
No, at the admission stage it has been rejected.
On the very first day, rejected.
No.
No, after 2 days.
Third hearing, at the
Third
third.
hearing.
See, the applicant was found ineligible for appointment in the force because of some physical deficiencies.
Yes.
She was to be considered in a Group D post.
Yes.
97, 98, 2001, every year she is writing that please do something. Somehow we are surviving hand to mouth. And nothing is being done
Page
for
48, for the page 48.
48.
Uh-huh.
No, we'll look into everything. If you don't want to file anything, we can
No, I'll file everything. Certainly.
then we can proceed right now.
No, but give me chance to file a debate, we certainly file a debate.
As and when vacancy occurs. When? After 2001, when did the vacancy occur? No vacancy ever occurred in Group D post.
No, because one of the number of total vacancy, 10% reserved for exempted category. And then, then again.
Where is the detail? This is a one-line letter as and when it will occur. How many vacancies are there? By when it is expected? Where is the detail? It's not a case of delay simpliciter. She has been pleading with you, begging with you in a way. That I have a 8-year, 5-year-old child and I'm somehow hand to mouth we are surviving. Please do something. File a reply, then we'll give you an opportunity, then we'll.
That is why, my lord, I wanted to show the papers before your lordship.
So we have seen it, yes.
Grateful. I'm grateful.
The Learned State Council.
July. Didi chalo. That 13, I appear for the petitioner. And I have a I seek my lord's mercy.
Where is the reasoned order?
That if your lordship kindly turns to page 47.
or 48?
46, 47. Contempt. 74. Over a type copy this name. 74. Actually. যাই হোক একই জিনিস ঠিক আছে The lordships also look into page 74. This is the interdepartmental communication from the additional district sub-registry to the district registrar on 14th of January 2015. 13 and 14 same husband and wife.
14 and 15?
13 and 14 same husband and wife.
Oh.
Their names are appearing. in the reasoned order. Rupali and Chon.
You're claiming benefit of which OM?
Well, I am claiming benefit of the government order. If your lordship kindly turns to the government order once.
61.
61. 68. First. 68.
Yes.
Well, till date, I am working. Both of them are working. If your lordship kindly sees, the ground of rejection, page 85 of the original application.
Yes.
That the court found, the tribunal found that the prayer in this application is for a direction of the respondent authorities to withdraw or impugn reasoned order. It is when so passed by the district registrar Nodia.
After 10 years, you have challenged the order. What can we do?
My lord has seen my financial condition. My lord, I am getting 2,000 per month. A person is surviving with 2,000. My lord, I want a protection from the government. My lord, I am banking on a government order. Now the government order says that if I work for more than 250 days at a stretch, I'll get the benefit of the government order.
For 10 years. For 10 years.
10 years.
Yes.
Now, kindly says my appointment. When from I am working?
No, that is immaterial. There is only one document that you have shown at page 74, which contains the details of the work performed by you.
Yes.
There is nothing else.
74 and 68. Same. 60 is pretty clear. 68 is the government order. And engagement 44 key is
74 shows that you have worked from 6 to 14.
Yes. Now
9 years. Now in all these 9 years, there is not 240 days is not there in every year.
That is their that is their version. If your lordship kindly takes up page 72 once, the reasoned decision in terms of the order of the original application of 2014. 28th of January 2015, the order was passed.
Yes.
The district registrar. Since 1975,
yes,
I'm discharging my duty as sweeper.
No, they will.
At the page 73 says, Chandan Halda, sweeper of the Swenso, has failed to produce any document to the effect that he has rendered at least 240 days in each year for the tenure as served by him. There is not only there is not any record of office concerned to the effect that as reported by memo number Swenso by the ADSR Polashipara.
You show us that limitation could have been condoned by the tribe. Unless you overcome that hurdle, where is the question of looking into it?
Very well. But may I come back tomorrow?
Kindly his statement
Hmm?
in the page 28, paragraph 3. The application said that instead application is not barred by any provisions of the Limitation Act as provided under the Administrative Act 1985.
No, the provisions are very clear. That cannot be done.
But I request your lordship.
Come to section 21.
Yes.
Yes.
If your lordship kindly takes the government memorandum once, page 68.
No, that everything will be seen after you cross the hurdle. What allows you to come to the tribunal as and when you please. In 14, you filed an OA. You got a direction. You went back to the authorities. And then
I went back to the authorities for the first time. The notification come in 2016. Kindly have a look at 68 once. That is what is my case.
notification? What notification?
The government notification of 2016, by which my right to get a paltry amount of fixed amount of so and so
in light
is
of
protected.
In light of 2016 GO, did you make an application?
But no.
Then you cannot approach the tribunal because of the bar under section 20 if you have not made an application. 15 order you cannot challenge because of the bar under section 21.
But only one handle I can give to your lordship, that is one legal notice that I have page 76. Kindly have a look. A demand of justice has been advanced to the respondents, page 76.
In 2024.
Yes.
After 10 years.
Person is getting 3,000.
See, that is not that is no plea. Firstly, secondly, you have already filed an OA. You are going to a lawyer. You are doing everything. So you can't say that there is some financial crunch because of which you could, and ultimately you have approached the tribunal. Again, we are asking you in light of 16, you could have made an application. And you say you are still continuing.
Yes, I'm still continuing.
Then
Both of us.
What stops you now even?
But if your lordship so grants me that
what is the requirement?
But if your lordship dismisses my petition, I will be nowhere. If my lord so grants a leave to me,
where is the 16 GO?
Page 68. This GO has come after the result order was passed.
That we have already said.
Absolutely. Yes. Page 68. I'm so great. But dismissed or disposed of?
Doesn't make a difference.
It makes before the authority ballot. It makes
Disposed of.
disposed of. I'm so great.
Next case also
Same.
same. What are the date line is same.
I did.
It is different.
Notification is same.
No.
No, government notification is same.
But order was passed on 28th January 2015.
Same. 20th Jan. দুজনের নামই দুজন একসঙ্গে সেম
28/115 same.
Limitation is keeping open. Limitation is keeping. Limitation point kept open. Limitation point kept open.
No, I will approach the authority.
His OA has been dismissed. Now he will approach for benefit under the memorandum of 2016.
That liberty court has granted.
Same order.
Great.
Item 15. My application is silence. The affidavit service kept at the the kindly come by the impugn order, lordships. If you, the petitioner was a casual worker and working for 1987, and last in 2013 he was compelled to retire from service. Their lordship, all on a sudden, lordship, one memorandum was issued from the government of West Bengal, and the petitioner has made an application for implementing the benefits. Lordship, kindly come. Lordship, may I read the impugn order, lordship? Hey, affidavit service.
Affidavit lage.
Affidavit দিচ্ছি, এই তো। এই যে।
Not sustainable, not against sanction post. Solid in one piece.
You file your opposition. Same one. 3 weeks. Then learned AGP.
Number 15.
আপনাকে নামটা লিখে দাও, আমি বলে দিচ্ছি 15 and 16.
16.
This is the same order. This is the same matter. Affidavit service. Lordship, the impugn order is also same. Same order. Impugn order is also same dated.
Same order.
Right. Visual.
Item 17.
My lord, I'm ready for a short passover, my lord.
Not today.
Item 18.
The petition I'm praying for not this week.
Why?
My senior is not there.
As prayed, list after week.
Item 19. 19.
I'm appearing on behalf of the petitioner, my lord.
Yes. No, your EMP 26.
Kindly see, within 2 years, there was a delay of 2 years, 8 months. Even to our 2016 circular.
He died on 12th March 2016.
Yes.
This is after the notification of 1st March 2016. This is after EMP 26.
Yes.
EMP 26 has come into force on 1st March.
1st March.
EMP 26 says that you should go and advise them how to do it. You have advised them, your superintendent has advised them to give the details. They have given within 2 months. Then file a reply. Affidavit in opposition.
That is my case, my lord.
3 weeks for filing opposition.
Yes, my lord.
अच्छा ये तो दे दे और ये तो नीचे रखा दे लिस्ट नीचे रखा दे
120.
ऑलरेडी डिसाइडेड
Item 20.
ना for the police go ahead okay okay
21.
call next
22. 23. 24.
But I am for the applicant, my lord.
the order wait no create RBW
That is the affidavit of service, my lord.
Why the review?
My lord, in this matter, my lord, the Union of India, my lord, although they have annexed the review petition filed in the tribunal, my lord, but they have not, my lord, bring to the record of the honorable court. My lord, in the review application, the order starts from 89, and my lord, on the basis of the order passed by the honorable court, that has been discussed, my lord. That is at page 91, para 8. My lord, though my lord, no document has been produced, my lord. Those documents was they are relying upon.
Has been produced.
You are for the Union of India.
I am for the railways. Respondents.
Review has been filed by the applicant.
No, review has been filed by the railway, my lord.
No, I have not filed the railway.
Yes, yes, in the tribunal. This review has been filed by the applicant.
Why?
My lord, the order passed by the learned tribunal, my lord, has been set aside by this order, my lord. But there is, my lord, there is a review order passed in the tribunal, my lord. Kindly see at page 89, my lord. That is the page number 91. My lord, may I read, my lord? 91 paragraph 8. That has not been brought to the notice of this honorable court.
Page 91.
91, my lord, of the application, main application.
order also has to be set aside.
And actually, my lord, the PT
We have set aside the challenge.
You have served review also. Have you served copy of the review?
My lord, I have served, I have given the
Copy of review has been served upon.
Since the main order has already been set aside, what remains?
Whether this is the ground for review,
Yeah, surely it was part of the record, not pointed out.
it's a part of the record, but in page 80, which they are relying upon, we have stated in the opposition that these are the documents through which we have stated that. But whether the petitioner has filed any opposition reply to our opposition, they have not filed any reply to our opposition. That
Yes, I have filed.
it is not in the record.
My lord,
Not in the record.
The review has been dismissed. The tribunal has dismissed the review. The main order already we have interfered with. What will remain?
Then kindly give me time so that I
Nothing will remain. Therefore, we are saying it is a futile order. He has challenged it because it is still remaining. But since the main order has already been set aside, what
Main
good
order
is?
has been set as a review order is doesn't matter.
Therefore, we are asking you. Yes, take down. The writ petition was filed by the Union of India.
Union of India.
Oh. So therefore, if they have not, what happened in the review?
my lord, in the review application was dismissed and the order, original order was affirmed.
Affirmed. So,
My lord.
So what difference does it make?
My lord, thereafter, my lord, in the Honorable High Court, my lord, that
They have
order,
not challenged the review order.
they have not challenged,
Yes.
but they have bring to the record, my lord.
So what is, why are you
My
here?
lord,
We don't know.
My lord, on the point, my lord, why I am here, my lord.
kindly see the order passed by your lordship that the learned council.
You filed the review before the tribunal.
No, I have not filed.
Before the tribunal,
Railway filed,
they filed review.
my lord.
Then what happened?
The review application has been dismissed.
They have not challenged that.
No.
Then what is your problem?
My problem is that, my lord, the original order passed by the honorable tribunal, wherefrom I get the relief, that has been set aside by the honorable court, my lord. That's why I have come before your lordship.
Why the review has been filed? We are unable to appreciate.
Because, my lord,
the OA has been allowed.
My lord.
That they have challenged.
Before that, they have filed the review.
That
But there was the OA is in their favor.
Correct.
There is a review.
Correct.
We filed a review and the review was dismissed.
Dismissed.
And it was in their favor.
Yes.
We challenge the OA order before this honorable.
But you did not challenge the review order. You did not challenge the review order.
The review order.
So that is on record, my lord. And that is not bring to the notice of the honorable court before passing the order. Because, my lord, what is the main reason of the quashing the order passed by the tribunal? That is answered in paragraph 8 of 91, my lord.
What has been done in the review? Let us see. Just wait. The review order is at page
89. But, my lord, the main.
With the OA because review
But
order fell.
that is at 91, paragraph 8.
Review
That
order
is the
failed.
title.
Admitted that he has done.
No, no, no.
In
I have
page
not
36
admitted.
In page 36, he has admitted.
That we have specified in anything.
My lord, why, my lord, here, my lord? The paragraph 3 of the order, my lord. May I read, my lord? Your lordships pass the order, my lord. That is on 20th February 2025. Paragraph 3, that the Learned Council for the Union of India submits that very foundation for the conclusion of CAT is factually unsustainable. In paragraph 15 of the reply of the Union of India specifically averted that the applicant was warned several times through verbal and written warning. In this connection, the Union of India has enumerated several letters. The letters and relevant period being later dated 6/7/2001, the applicant had also given an undertaking that he would not repeat his acts of indiscretion in future. The applicant has filed a rejoinder. He, however, has chosen not to deny and dispute such warning was given to him by the said communication. My lord, paragraph 5, my lord, on consideration the rival submission of the material including the reply and rejoinder filed before the CAT, we find that the submission of the Learned Council of the Union of India to be sustainable. The Union of India before the CAT has clearly demonstrated using the letter prior to adverse entry being made year 2001-2002. That's why, my lord, I have, my lord, address your lordship to bring. My lord, they have not produced any document they are relying.
You want a rehearing of the matter?
My lord, if your lordship.
All right, Learned Council submits that.
No.
Item number 25.
Council means that it will. Which is that?
My lord, by last order, this honorable court has been pleased to grant leave to file the documents. My lord, this is with regard to plying of unregistered e-rickshaws in violation of section 39 of the Motor Vehicle Act. On the last occasion, your lordship is of the view to establish the locus standi. I need to file the suit which I have filed before the Learned Alipur court, my lord.
You have given copies. Who are you? Supplementary affidavit. Given you a copy, you have the opportunity to go through and to file a reply if
Item number 26.
None appears for the petitioner.
For the petitioner, I am appearing for the respondent on behalf of my learned senior, your lordship. My senior has gone for to attend Port Blair circuit bench, your lordship. So I am praying to your lordship any day after Tuesday, your lordship. After tomorrow.
After?
Tomorrow, your lordship. He will return on Tuesday, tomorrow. Any day from Wednesday.
Not.
Not today and tomorrow, your lordship.
Tomorrow you seek an adjournment.
Adjournment.
Item number 28. Well, I am for the petitioner.
My lord, 28, my lord, Mr. Divendra and Ray is appearing for the respondent, my lord. He's just left the court, my lord, and informed us.
I am filing the exception taken. $29.
That item Have you seen the last order? Yes. My lord, actually what happened, my lord? After the order of the contempt, which is, my lord, the contempt application was rejected. But my lord, prior to that, the learned tribunal had passed one order. And in compliance of that order, my lord, the railway has considered the entire case. But unfortunately, my lord, due to the lack of, my lord, the communication We have failed to, my lord, that produce those documents.
Lack of?
My lord, due to the lack of communication in between the railway and, my lord.
We ask you, have you seen the court's last order?
Yes, my lord, kindly see that.
Have you seen our last order?
Yes, yes.
What you were required to come with today?
My lord, that regarding that MA application which was filed by before the tribunal. But my lord, the new facts has come before. That is my submission, my lord. My lord, kindly for a moment,
Kindly read the last order, sir. You were appearing on that day.
Yes,
Still, you don't know head and tail of what has happened. The least is expected, you will go through the order sheet. Why the matter has been listed today? You are starting off on a new tangent, as if the order means nothing. We asked you twice, have you seen the order? You say yes. You are clueless. What was the order? Tell us.
my lord, that to take the instruction regarding the MA application which was filed before the tribunal.
Therefore, we are saying you are clueless. You are least bothered what the order court has passed.
And my lord, for this decision, my lord.
You are least bothered for the court's order. We asked you twice, have you seen the last order? You have not seen. You did not bother to see even. Forget about respondent's attitude. We are looking at the counsel's attitude. Unfortunately. Show him. This is not expected from any advocate, much less from persons like you, experienced persons like you. Having no regard for the last.
That is, I am also submitting that.
What is the last two paragraphs? Read.
My lord, the learned counsel for the railway submits that he will obtain necessary instruction whether the process has been initiated and or format has been handed over to the
What is the process referred to in the court's order?
That process has been completed. That is my submission. For decision, I am submitted that.
See, then you are trying to unnecessarily derail the issue. The court's order is clear.
Yes, my lord.
The tribunal has recorded that process has been initiated. That means prior to recording by the tribunal. And you are saying something subsequent?
My lord, after this order.
We are not after this order.
My lord, what
We are what have you submitted before the tribunal? Which process has been initiated? That we are asking you. Why you are saying after the order?
Yes, my lord, that what process has been initiated, that has been completed. That is my submission, and that is the order of the concerned officer of the railway. Considering the entire issue, my lord.
Let us see. When it was initiated? What is the date? Tell us.
My lord, 4/4/20. My lord, the 23rd of December 2022.
23rd of December 22.
Kindly see this.
My lord, they have not given the format. Order. This is nothing. This is nothing. This is not in response to the court's query.
But that was also in
Then prima facie it appears you have made a false submission before the tribunal. Look what you have said. In compliance of the order passed by the Honorable High Court on 1/7/21 in WPCT number so and so and so and so, with respect to processing the case application of landlords including the case of the applicant, the competent authority initiated the process of recruitment. This is what you have said. This is the initiation of process of recruitment.
My lord, his case was considered, and that was, my lord, the rejected, my lord, due to non-compliance of the, my lord, the minimum requisite things, my lord.
What is the minimum requisite?
My lord, that minimum requisite, the applicant, my lord, kindly see the last paragraph of this, my lord, the 4th May of April, my lord, 2024. The applicant is not a displaced person. He is the land acquisition ground and had received due compensation against acquired land. According to the circular dated such and such, the displacement is the prime criteria for consideration of appointment in the railway against land acquisition ground. Hence, the applicant have not fulfilled the basic criteria of the railway board circular number such and such for consideration of appointment in railway. It is pertinent to mention that policy for appointment in the railway for land acquisition ground, which was under review, has been withdrawn by Railway Board order circulated number such and such dated 11th November 2019. Therefore, it is reiterated that the case of the engagement of Sri Sukhdev Thakra cannot considered in the light of the above. Hence, claim of the applicant is devoid of merits. Claim cannot be considered. As such, the order of the Honorable CAT Kolkata dated 23rd December 2022 passed in way number such and such.
So because the policy has been withdrawn, you will not consider.
Not only that, that according to that policy, which was existent in that time, the primary consideration for the certificate of displacement, that was not there, and that was to be given by the state government.
Yes. Yes, my lord.
And the railway has that certificate was not to be given by the railway. That was to be given by the state government if really the person has been displaced.
But you have told the tribunal that you have initiated the process of recruitment. This is your stand recorded in the tribunal's order.
Actually, my lord, what happened? That 7 matter was, my lord, the disposed of on
it says including the case of the applicant.
And my lord, kindly see.
Therefore, we have recorded this order. Show us what process you have initiated.
My lord, kindly see that that was a suppression of fact, my lord.
That was your submission, never challenged, never assailed.
Yes, my lord.
What do you mean
of that-
suppression of fact?
Because of that fact, his case was considered and rejected.
Sir, this rejection is of April 24. And this, when it has been recorded in the tribunal's order. What are you talking about suppression?
My lord, the tribunal initially.
What is the date of this order in which your submission has been recorded? May 23. Where is the question of suppression? This is a document in your custody. It has come into existence 1 year after this order. Where is the question of suppression? Don't just say anything. This document is 1 year after this stand was recorded by you in the tribunal.
When the writ petition was affirmed, my lord.
Forget about writ petition. This is your stand recorded before the tribunal.
Yes, my lord.
It is a quotation from the tribunal's order in 23. Where is the question of any suppression?
When the matter was heard, my lord, at the top, my lord, kindly see the order dated page 92, my lord.
Why? After seeing everything, we have recorded this order that you show us how you have initiated the process of recruitment. Where is that initiation? Show us.
My lord, particularly in this matter, on 23rd of December 2022, matter was heard.
Yes.
And on that day, my lord, some order was passed by this honorable tribunal. And my lord, that matter was heard 23rd of December, but my lord, the judgment was passed in this contempt matter, my lord, of 9th of May 2023.
Correct. Yes, we are saying 1 year before this.
And my lord, in this my lord order dated 4th of 4/4/2024, that was recorded that order of the tribunal passed on 23rd December 2022.
Yes.
And in compliance of that order, my lord?
Not in compliance. In that order, you have said we have already initiated. That we are asking you, whether you have stated a correct thing before the tribunal or you have made a false submission and misled the tribunal to dispose of the contempt application. That we are trying to ascertain. Show us where is the initiation referred to in the tribunal's order.
My lord, my lord, till date, my
That
lord,
is the court's
I have not
order.
received
You
any-
comply with this court's order. Don't show us this document and that document. You comply with this court's order, last order. You show us, or you say that it is wrong.
My lord, actually, my lord, prior to that, that has been, my lord, that considered, my lord.
No, it has not. That is 1 year after this. This is of April 24 and this is of May 9, 23. Don't try to unnecessarily derail the issue or mislead us into some conclusion. First, you have done it before the tribunal. Now you want to do it here.
And my, that was, my lord,
This was, we are not concerned. You comply with the last order. You show us where is the process or you file an affidavit in response to the last order. We have to see whether you have made a false statement before the tribunal or not.
my lord, I have not yet, my lord, taken any, my lord, no, they have failed to serve any instruction, my lord,
Huh?
regarding that. My lord, regarding that compliance of the tribunal order.
Not tribunal order, this our last order.
Of your lordship's order?
Yes. You were to seek specific instructions. How the process was initiated, when format was given. What? File an affidavit. We'll decide the issue.
That instruction is given, my lord. That is the order of 4/4/2024.
No, that is not. That cannot be. You are required to show something prior to the order passed by the tribunal May 23, not subsequent thereto. That's why we are saying don't try to derail the issue. You cannot take an oscillatory stand, something before the tribunal and the other thing here, and they will keep running for decades. This we will not permit. Either you have to stand by what you have said before the tribunal, or you will face the consequences for making a false submission.
I have placing the record what was happened, my lord.
No, we want an affidavit. You give us an affidavit in response to this last order. We are not going to accept such documents like this. This is a writ proceeding.
You
can't just pull out a document from the hat and give us like this.
Actually, what happened, my lord, in this matter, no affidavit in opposition was filed, and no such direction was also there. If your lordship give me that opportunity.
We have put a specific query to you in the court's order, referring to your stand recorded in the tribunal's order. We said you have told the tribunal that we have initiated proceedings for recruitment. Show us what proceedings you had initiated, which you got recorded in the tribunal's order. Show us. Need not necessarily go in his favor, but show us when you said to the tribunal on 4/5/23 that we have initiated a process, what process you had initiated prior there? Show us. That we have asked you, and you are showing us something of April 24. Why should we consider? Why should we consider? You show us. You file an affidavit. If you have done something, then we don't know.
My lord, I can disclose these documents by filing an affidavit.
We don't want that document. You can do whatever you want. But you have to sustain your stand before the tribunal or reap the consequences, either way. You can't derail the proceedings or the query in this way. When the court has put a specific query recording your stand in an affidavit, in a tribunal, you are showing us something else. This is not expected. At the very outset, we understood what you are doing. Still, we have looked into it. That is not a reply to this query. You file an affidavit. Take down. Give it back.
Shall I take back those documents?
2 weeks.
Shall I take back those documents?
Yes, you take it.
30.
My lord, I'm praying for not today on behalf of Sukumar Bhattacharya, appearing for the petition.
Not on behalf of the respondent.
Not today.
31.
My lord, I beg to appear for the petitioner. My lord, Mr. Sukumar Bhattacharya is appearing for the respondents, and on the last date, he has served a copy of compliance affidavit on behalf of the respondents. My lord, may I be permitted to submit an affidavit in opposition against that compliance affidavit?
Compliance report has been submitted.
One affidavit, my lord, they have filed. And it is served upon me also on the last date.
You are for? I'm praying for not today, my lord, on behalf of Sukumar Bhattacharya, appearing for the respondents, my lord.
Respond number 6. Not, he won't say not today, we'll take it up tomorrow.
No, my lord, I'm just praying for grant of leave so that I can file an affidavit in opposition.
Affidavit in opposition to what?
An affidavit, my lord, they have submitted in the last week based on their submission. My lord has.
They have not given us yet. Unless they place it on record, what can be done?
Apology, lord.
Not today.
My lord, item number 34 is also same matter.
Next.
32.
My lord, in this matter, Mr. Parthaprati Mukhopadhyay is appearing on behalf of the petitioner, my lord. He is seriously ill. I'm praying for 2 weeks of accommodation.
2 weeks?
He is from January.
My lord,
Initiated on behalf of Mr. Haradhan Banerjee. Time was wait for. Can I kindly say how many days it has been adjourned? January, February, March, April, May. Now we are in June. Normally, somebody ill, we do not oppose. One Amitabh Pine appeared. Then Tanmoy Khan also appeared. Then Haradhan Banerjee appeared on 21st March 2025.
Wrong file. Wrong.
কবে ডাকলো? Kindly see the order dated 11 March 2025.
My lord, I only have this instruction to adjournment this matter, my lord.
Mukadama record came.
Adjournments. The infirmity in the order. Tell us. Sorry for the adjournment. Take down.
33.
33 is the same prayer.
To make alternative arrangements, failing which the court will
My lord, in item number 34, I am for the petitioner.
Yes, what did we do in the other matter? No. You were appearing in 31 also.
Yes, my lord.
This will also come. What have we done in that matter? Not today.
Not today.
So let them come. Not today.
Gratefully, your lordships.
In this matter, on the earlier occasion, Mr. Subhisanil has made his submission. And today he is engaged before the another court, so kindly make it not
Who has
today.
made submission?
Mr. Subhisanil has made his submission.
Then?
Yes. Was that Eastern Railways matter, your lordship?
Well, Mr. Bagh is appearing on behalf of his own leg and another court.
Kindly keep it on tomorrow.
Not today.
Deeply opposed.
Great.
Thirty-six, my lord, I am praying for one day accommodation, my lord.
Union of India.
Yes. I am also there virtually, your lordship.
I'm for the respondents, my lord. I am praying for one day accommodation, my lord.
Similar point is pending before this Honorable Supreme Court. Lordship, I had given an order where it was stayed till the 24th of March. Your Lordship said, asked me to get further instructions, Lordship. The next date is fixed on the 1st of August, Lordship.
Then 1st of August,
The Supreme Court fixed for it.
So the order is still continuing.
Lordship, I'm handing over your case, Lordship.
Yes.
That is what is happening.
That stay order which is granted till 24th of is granted on 10th of February. Made returnable on the 4th of March. But now it has been made returnable on the 1st of August. Till the 1st of August.
If it is still continuing, why to adjourn it? Let it come after
Just
some
want
time.
the accommodation, my lord. Mr. Bhattacharya is arguing before your lordship.
What arguing? It is not to be heard. What do you mean arguing? There is an interim order. In view of the interim order, it has been adjourned. Continue. There is an interim order by the apex court. What argument is to be?
What your lordship deems to pass.
The Learned Council for the Union of India submits.
Is the case is that after the retirement of the employee, where is the no fault of the employee, the department has said that the benefit has been withdrawn. Your lordship was of the view that whether this order is at all applicable, Supreme Court order is at all applicable.
That doesn't appear from the order. Next case.
37.
Your lordship, if my presence will be recorded also.
Yes, yes. Give your somebody must be here.
Yes, yes.
Ask him to give the appearance.
That's
You are for?
Waiting for the
Give the
37, I am praying for not today, my lord. Mr. Devobroto Karan is appearing on behalf of the petitioner, my lord. He is on legs before, my lord, just show mention, my lord. Over. Only not today. Only not today. Not today. I'm grateful.
I'm for the petition. This relates to compassionate appointment, my lord. The last occasion, lordship directed the state to produce the record.
Directed to produce a record. In the meantime, during the vacation, can you give me some time?
We have not got it yet.
Give me some time,
2 weeks for the time
39.
My lord, I am praying for not today Mr. Shubir Banerjee appearing for
Not
the
today.
petition. So,
40.
Your Lordship, in this matter, Senior Advocate Bikash Ranjan Gotcha is appearing. Your Lordship, I am praying for a week's accommodation, Your Lordship. He has traveled to Delhi.
Week.
He has traveled to Delhi, Your Lordship. That's why I am praying for a week's accommodation.
As prayed, list after 1 week. Give a date of 18th.
Forty-one.
41, I appear on behalf of the state, Your Lordship.
Nobody, not today. Let's see. Not
42.
next.
43.
Lord, I am for the petition.
I am for the respondent, led by Shomu Muru, Planet Senior.
Challenging the order of the tribunal.
Take it not.
You are for respondent.
I'm in 30.
One matter, my lord, he is the respondent, and one matter, he is appellate.
Oh, there are two matters.
Same order, my lord, we filed the Union of India
All
file.
right, not today.
Yes.
Forty-five.
For the petitioner in item number 35 to 47, they have filed their opposition, my lord, only yes. Last occasion, guided to find the opposition. We have already started the process of opposition in 3 matters. I am getting
45, 46 and 47.
I would like to file a reply. Only BSNL has filed. They have
BSNL is answering respondent.
1 week.
1 week, my lord.
1 week.
1 week.
Affidavit in opposition be taken
Kindly
on
make
record.
it 10 days, my lord. Kindly make it.
All 3 cases, same order. Yes, give all 3 matters. Give separate.
Advocate.
48.
48. Thank you. No, 47. 48. Takes 47.
Yes, not today. Call the next. Call the next. Respondent.
Last occasion, your lordship directed to take instruction. I got the instruction, but
On what point?
land user matter here. It is Devento.
Let them be here. None appears on behalf of the petitioner.
Some personal difficulties other than
Huh?
16, some difficulties met there.
In the next week, 17th.
I am for the petition. But this matter pertains to a shortfall of service of two petitioner before your lordship. In respect of one petitioner, only 7 months, 17 days. And in respect of another petitioner, full in 2 years, 9 months to 29 days. The shortfall of employment or appointment has been caused, which is not attributable to the petitioner themselves. Selection process selection process started in the year 1995. 1995, due to some court cases that was the selection was stayed, but it was subsequently continuing in the year 2007. It started 6, but it is completed 2007. Ultimately, appointment given in the year 2009. And petitioner number 1 retired in the year 2017. Petitioner number 2 retired in the year 2018. And that is the causing for delay. Now, authority, at the time of giving approval of my appointment, they have understood the future problem regarding shortfall. They have themselves condoned the delay for approving the same. Now, thereafter, it was sent before the finance department. They kept pending the matter. Now, without taking any course, petitioner made the representation after the retirement. That was not considered. They preferred an original application before the tribunal. Tribunal directed the authorities to take a decision in the light of the judgment passed by this honorable court in the similar situated person in WPST 112 of 2012-13. Now, the authority took consideration of that. They have approved that shortfall, sending the matter to the finance department for granting our pensionary benefit.
Where is that document?
Yes. But first, I am placing the order passed by the authority concerned first, passed by the tribunal itself, page 81, regarding consideration of our representation. Judgment bar for 112 Justice Doctor judgment. Yeah, আমি আমারটা দিয়ে এখানে বার কর না, এখানে আছে। After hearing,
yes,
observation has been made. Internal page 82, running page 82, internal page 2, paragraph 11, 12, 14 of the judgment itself. I have handed over to your lordship that judgment I shall place. So, considering that, page 83, that consideration order, my employer reason order has been passed in our favor, not rejected. Page 83.
taking consideration of the honorable division bench judge. আচ্ছা জজমেন্ট যেটা বার করে 215টা বার কর আমার এখান থেকে last paragraph, since the present application similarly circumstances set at case, the court directed the respondent number 5, the registered assurance, to dispose of the representation of the applicant dated such and such, taking into the consideration of para 11, 12, 14 of the judgments of WBST 112 of 2019 by way of passing the rejoinder order. Therefore, the respondent number register of assurance Calcutta, the petitioner Sri Mihir Kumar Jatua and Punil Kumar X Sri, learned advocate on behalf of the such and such present at the hearing. Now, in furtherance, it appears the above mentioned memos and records of both the employees are engaged on the basis of the government order and rules such and such. Therefore, the superannuation from the government service, Mihir Kumar Jatu and for the superannuation from the such and such respectively. In furtherance, it is mentioned that a qualifying service of Mihir Jatu 9 years, 4 months, 13 days, Pulin 7 years, 2 months, 2 days, which is less than such and such. Now, in view of the above, at page 85. Now, page 85, in view of the facts such and such, as per order of the tribunal, may also be considered and be forwarded to the Honorable Inspector General Registration and be considered in stamp such and such towards the transmission of necessary order in the light of the view and spirit of the circumstances in WPST.
What has the tribunal done?
Now, again, my lord, they have not taken any step. I had to go before the tribunal again. My lord, last page. So that can be implemented. Representation considered and that should be implemented. I had gone there for implementation of the same. The tribunal says in terms of beyond 6 months, it cannot be. When the earlier order reached its finality without any appeal by any authorities of the state, whether they can subsequently take the 6 months, constructive judicial with great respect, I'm saying so. And that too, the authority in terms of that judgment or order by the tribunal, considered the same in the light of the WPST 112. I have given a compilation, your lordship will see. If the delay is not attributable to any part of the petitioner, your lordship also held that. Last occasion I had handed over the judgment also. Now, during the course of proceedings, I must be candid too, they have filed 1 page, they have given 1 page communication to your lordship. By way of CAN application, I have also dealt with this. Last page, the tribunals.
They have passed some order.
Not order, it is a communication to the state advocate that since beyond the 6 months as propos of the tribunal's finding. So, they say, taking the plea, that since the communication has been given in a negative way, I had to go again before the tribunal citing 1 judgment. That judgment is also distinguishable in feature because in that judgment, 1 application filed by the similarly situated person before the High Court in a proceedings carried out by some other person in that WPST matter. Now, Honorable Supreme Court in that case says, no, since you are not the original applicant before the tribunal, by way of addition of party, you cannot file any application before the Honorable High Court. You have to avail threshold in terms of the L. Chandrakumar's case.
10-4 SCC.
My lord, my case is different to that because I am the harping pillar 2 post for getting our pension.
No, but if they have passed an order, it has to be assailed.
Your lordship can deal to. I have given the constitutional bench judgment. In those matters, during the pendency of those writ petition, 1 communication rejecting was there. Now, Honorable Supreme Court said no. This type of rejection cannot be passed. And Honorable Division Bench, Honorable Constitutional Bench, set aside that and the appropriate direction was given. 2007 Supreme Court. And your lordship's judgment also there, 215, paragraph 5, 6, 7, 8, and I have handed over all these judgments.
215.
WPSC 215.
Yes.
During the pendency of this WPST, order judgment dated November 26, 2024. And I had handed over the constitutional bench 2007 4 SCC 270. Yes. 270. Paragraph 6 to 10 are the facts similar to our case. And observation paragraph 40, 41, 44, 53. And last judgment, last occasion, কোনটা জানো এটা দিলাম না 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 ওইটা যেটা আরেকটা দিলাম যে কদিন আগে যেটা হলো আরে না এই কদিন আগে যেটা দিলাম এইটা 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 টাইপগুলোতে দিয়েছে বললাম না না এটা না পেলি না সমস্যা কি জানিস তো এখানে তুই লাস্ট অব্দি আমাকে করতে লাস্টে দিলাম যে একদম লাস্টে কদিন আগে দিলাম না হ্যান্ডেড ওভার করলাম দিয়েতে দিয়েতে এইটা বোধ হয় হ্যাঁ এইটা এইটা
So according to you, the period between 2007 to 2009, if it is taken into consideration, then both of you will go through.
First thing. Second thing, due to pendency of a litigation, if someone proceeding of appointment stayed or due to court case, that is the kindly if you lordship sees the judgment of Justice Dipankar Datta held, paragraph 8 onwards. Similarly, set of facts. In the compilation first judgment. I had handed over this type of compilation with lordship judgment and other honorable division bench. First judgment. It is authored by Justice State Justice Pratik Prakash Banerjee and Forum was Malay Justice Datta and Malay Justice Banerjee or late Banerjee. And if your lordship kindly come to paragraph 8 onwards. There are also some delay on the part of the authority for giving appointment.
See, delay which is attributable to the authorities.
This is
but where the delay is on account of pendency of a court case.
Yes. Then the application of doctrine or that due to any act of the court, litigant will not suffer. That judgment is also there.
Which litigant?
Litigant in the process.
Litigant means the state also. Both are litigants to those proceedings.
Yes. Who are the beneficiary of that proceeding?
Whatever it is.
Whatever.
But can they be saddled with a liability because the court case was pending?
If that is so, yes, that part
that
also.
Is one aspect also.
Yes, that part
where is the
paragraph 8.
8.
Yes. May I read for our viewers? You can read.
No, in this case also due to court case.
Yes. Litigation was there.
It is the same recruitment process.
No, it is in respect of, I believe, another.
Because here also it is between 2007 to 2009, same
And
period.
in my case, 95 to 2007. This is in respect to commercial tax appointment matter. Yeah, anyhow, a ratio has been laid down by the Honorable Division Bench. And that argument was there by the state advocate.
So in that case, the coordinate bench has taken the date on which the tribunal had passed a mandatory order from 2007.
Yes.
After that, not the period.
Anyhow, in my case also, my lord, tribunal directed the authority to consider in the light of this judgment. If that is so, even then, my lord, we are.
In your case, which is the date of that order?
My lord, the initial order of the tribunal at page 80, 20.
When? No, that is not the order that we are talking about. In the case that you are referring,
After retirement,
in your case that you are referring, the tribunal on 2nd August 2007
yes.
passed a mandatory order to appoint the applicant.
Right.
After that, there was a delay. Therefore, the coordinate bench has given the benefit with effect from 2007. In your case, there is no such.
My case, no, ratio. Ratio has been decided, they have not denied till date, or they have not challenged that order itself. The tribunal directed, page 81. Consider the light of the judgment.
Tribunal directed to consider grant
They
of
have considered.
grant of pension.
No, consider in the light of the judgment whether our case should be considered or not.
Correct. Whether
They
it
have considered that.
But the case you are relying upon is different.
Yes.
There the direction was to appoint in 2007.
My lord.
Still appointment was not being given.
That is there. But in my case also, they could have considered, kindly come to page, initial order passed by authority at page 6, at page my lord, 62 and 63.
No consideration whether it is done 2 years earlier or 2 years later. That is not relevant.
Not is not relevant. But authority, they have condoned at the time of initiation of my appointment also.
That we have seen.
Yes,
The minimum age has been
to be condoned.
the maximum age has been condoned.
Man, has to be condoned.
Yes.
It's 63. Taking into consideration of our future my lord, pensionary benefit or notional benefit.
No, only age has been considered.
That means
That means everything. Under rule 8.
Hmm?
Maximum age. It's set by the government in 5th August 2009.
But the governor also has power to condone this delay. Kindly see. See the DCRB. Yes.
It's not a compensation pension, it's not an invalid pension, it is superannuation pension, retired pension.
What is 27 January 2005? No, this could not have been done. This could not have been done. This is after the tribunal's order. The tribunal's order said that it cannot be done. The tribunal has said both things. It has said that it cannot be done. Still you consider.
I think that's the opinion of the tribunal that since a proposal has been submitted by the inspector general.
No, sir, read the earlier paragraph just before that.
6 months এর বেশি করা যাবে না।
Mr. G.P. Banerjee.
That is condonation of qualification service, short qualification service, the discretionary power of the authorities and it's apparent from the written order that two applicants of short discretionary power cannot be considered exercised by the respondent. It is submission.
Oh, it is only submission.
Submission of Mr. Banerjee. Having learned the learned council's opinion, the tribunal that seems a proposal submitted by the registration and commissioner of stamp revenue dated 9th December 22, respondent to a special secretary finance department make a decision as to the route applicable at this term with a period of time.
You have filed only one way.
Yes, not challenging this communication. I have filed as per lordship's leave granted to me. You file a CAN application, we shall deal with. But I have filed also CAN application challenging this before your lordship. CAN is there.
No, we are asking you another thing. You have filed only one way or prior to that also?
No, one way.
Only one.
Initial way, there was a consideration, right? This is a second way.
First was for consideration.
Considered in the light of the judgment of the Honorable Division Bench, page 81.
And then the order was passed.
Yes, order was passed. I have prayed for implementation of, since they have considered for implementation. Now tribunal says it is to be another consideration, not that the rejection. So I am paying for implementation of that.
Court case was pending. One table relaxation was granted. and he accepted it in 2009.
That submission has been turned down by the Justice Chakraborty division man. Similar type of matter I have annexed. Since at the time of appointment, I did not raise this type of objection, I cannot at the time of retirement. That plea, but I have shown a judge, I have to show a judgment of Justice Tandon held against him personally. Held whenever he argues the matter as per his decision, it is to be done. Kindly see that observation he has, Justice Tandon division was made. This argument already decided. Now he is making same argument before your lordship. Justice Chakraborty held that. I have annexed page 12 of the compilation. At the time of initial appointment, if I do not raise any objection, Mohan Kumar Haldas, yes. And another settled law. ওইটা দেখো হ্যাঁ হ্যাঁ দিয়ে ওটা বার কর
This order of 27 January 25 has to be challenged.
Not subject to correction. We get your lordship, my lord. This is a pensionary benefit. Your lordship can mold the relief for ends of justice because it is not their case. They have not decided anything. It is my case that they have considered my case in the positive manner. Therefore, they cannot take the plea. That, and another settled proposition of law is this: if there are two authorities of the government wing, one authority is decided in my favor, another authority cannot turn down my prayer. That is also settled provision.
Point is that which forum is to consider this?
Yes, your lordship can, because I have prayed for implementation of the order, not rejection. So if I go there,
No. Now you have to, there is a rejection.
Rejection, I have filed a CAN application in terms of your lordship leave. Your lordship can.
You can challenge everything, but whether we should entertain
That is your lordship, constitutional bench judgment I have shown 2007.
How that helps you, we are unable to see.
Yes, paragraph page paragraph 4 to 10 are the similar set of facts.
Paragraph
4 to 10. I am giving the judgment itself.
4 to 10.
Yes, fact. And proposition of law has been laid down by the Honorable Apex Court. What is judgment?
No. We are faced with this question.
Yes.
Based on decision of the Apex Court 1997 3 SCC.
Yes.
Thereafter 2010 4 SCC 554.
Grateful.
That is not applicable. This is a different circumstance altogether.
Subject to correction.
Here there is no judgment of the Apex Court giving jurisdiction to look into it, and at the same time saying that there has to be a first, that has to be the forum of first instance.
My lord.
That is not the circumstance here.
No, here during the pendency of the
there are some election disputes.
that is there. Now, the judgment which has been relied on by Mr. Mukherjee is different proposition.
It doesn't appear to be.
Yes.
It is relying upon
an application filed by a third party.
It is
during the pendency.
It is relying upon paragraph 98 of the judgment.
I have seen this, my lord. I have also brought this. I have read this in the proposition. The original application was pending before the the WPST was pending before the division bench for certain relief by some persons. Some third party came and filed an addition of party.
However it may be, the court has merely reiterated paragraph 98 of L. Chandrakumar judgment, where it says that the tribunal shall continue to be the court of first instance.
That is there.
The Apex Court has held that the
following L. Chandrakumar's case.
This extraordinary discretionary jurisdiction under 226 cannot be curtailed, but at the same time, in the same breath, it has said that the tribunal shall continue to be the court of first instance. Therefore, it has not left it open for the writ court to take up every matter unless it comes through the tribunal. It has said.
I got your lordship's point. Now, my case is different to the case of others.
Let us see.
To that extent that it is the implementation, not the rejection.
Not anymore. Now there is a rejection. That is the whole point. Now in January, there is a rejection. That has to be questioned and that has to be looked into.